long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government, hug the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Trey Orndorff, a political scientist at Oklahoma Christian University, and I am joined by Professor of Law at Chase Law School, Ken Katkin. Ken, it's fun to be doing the show again with you after getting to hang out with Mike last week.
Yeah, it's great to be back, and it was great for me to see Mike in person. That doesn't happen as much as it used to.
Well, you know, you get retired and life gets busy. Well, but it is fun to kind of have our pairings back and to be back on the show. And of course, that means, again, that we'll be getting to pick back in for those of us who want to be part of our supporters exclusive show, to be part of our Constitution as we almost now are going to be finishing up the original Constitution and the Bill of Rights. We won't be done. We're going to continue with the amendments, but we're getting done with kind of another milestone on that. And don't forget, that's part of our supporters exclusive midweek show. What we're going to be taking on today, though, well, things kind of got a little hairy. So, Ken, you know, we had things lined up, ready to go for our show here on Friday, May 24th, when, well, the ICJ decided to drop a little bit of a bomb on us, which was a decision that in part is requiring Israel to, well, that's what we were taking a look at this morning, and we're going to need to talk about this a little bit. One of the things we had chatted about a little bit when we were taking a look at this was, so the ICJ had this order, and a number of news outlets are reporting on it. One of the things that kind of always bothers me, for those of you who listen, is I am a citation stickler. I like locations of things. I want to get to the original documents, which was not particularly easy to do. But we got there, and we've got this. And so if you're interested in this and you're taking a look at it, we're taking a look at the kind of the conclusions and the measures to be adopted. And I think the one that's getting the most attention this morning, as we took a look at this before the show started recording, was this piece under 350. And it says this: the court considers that, in conformity with its obligations under the Genocide Convention, Israel must immediately halt its military offensive, and any other action in Rafah Governorate which may inflict on the Palestinian group in Gaza conditions of life that could bring about its physical destruction in whole or in part, end quote. And so, Ken, what we were talking about before the show was, is this a clause of wiggle room that is being ignored, or is this, as I was kind of reading it, three separate pieces to the order? And so what does this mean for the ongoing conflict in Palestine and Israel?
Right. Well, it's a breaking news story right now, and we're talking about it on Friday morning. But by the time the listeners hear this on Saturday, I'm sure there'll be a lot more news reporting on it. But the early news reporting is generally headlining this as that the ICJ has ordered Israel to halt its military offensive in Rafah. And I actually don't read it that way. I think it has quite a lot of wiggle room as worded, and does not order a halt to the military offensive. I think the most natural reading of this language is that Israel is being told to halt its military offensive and its other actions in Rafah, to the extent that those actions may inflict on the Palestinian group in Gaza conditions of life that could bring about the Palestinians' physical destruction in whole or in part. So that it's permissible for Israel, even under this order, to continue its military offensive, so long as it does so without bringing about the physical destruction of the Palestinians in Gaza in whole or in part. So I would actually read it as being more measured and leaving more wiggle room for Israel than I think how a lot of the early news reporting is reading it. As a practical matter, and I know you might have a different reading of it, but as a practical matter, Israel's either in compliance with it as they might be, or more likely they're out of compliance with it, but it's not going to affect what they do in any way, I wouldn't think.
I mean, even as of this morning, Netanyahu has said that there is not going to be any change to what they're doing. So no, I think pragmatically you're there. Yeah, I do. As we were, again, we were reading and looking at this together. But I do think this is a list, and I think number one on the list. I'm not necessarily agreeing with it. I'm just saying I think number one on the list is that you've got to be in conformity with the Genocide Convention. Two, that Israel has to halt its military offensive, and I think that. What you kind of see as being the wiggle room clause is actually related to the any other action in Rafah, not to the military offensive. But that's why you pay lawyers a lot of money, I guess. No,
Yeah,
I guess
the reason. So it really comes down to a comma. This is not ideal for radio or podcast because we can't put the language up on a screen in front of our listeners.
That's true.
Yeah, but I think what you and I are both the only part we're probably disagreeing about is the significance of the comma after the word governorate, the Rafah governorate, right? So I think that comma there means that the clauses that follow apply to both the first clause about halting the military offensive and the second clause about other actions. I think if there was no comma there, then the words beginning with which would only apply to the other actions, which is how you're reading it. But I guess I read it that way. But it's either way, it's certainly people are going to argue about this. Maybe we should talk about the other things in the order because I think Israel probably will comply with the other things in the order. For instance, subsection B orders Israel to open the Rafah crossing for unhindered provision at scale of urgently needed basic services and humanitarian assistance. Now, I guess that last part they're not going to comply with. They're not going to have unhindered provision at scale of urgently needed basic services and humanitarian assistance, but I would expect them to reopen the Rafah crossing, at least under the kind of lines that it was open before, where trucks that are coming in with supplies are allowed to come in, but that they're closely inspected as they come in. That may slow things down and be counted as a hindrance, but I would not expect them to keep the Rafah crossing completely closed as it is now after they've been ordered to open it. They're ordered not to impede access to the Gaza Strip by UN commissions or fact-finding missions. And I guess they probably will impede it a little bit, but I think that they're not going to bar the UN from coming in there, and they really haven't been barring the UN from coming in there. And in fact, now the UN have an easier way to get in there because the US has set up the pier that goes out to the US naval ships, so there's an easier path into Gaza for outside bodies like that. And then they're ordering Israel to report to the court on measures within a month. I suspect Israel will file those reports because they have been participating in these proceedings. We were talking about 13-2 votes. One of the votes, the two in the dissent, of course, was Israel. It was Judge Barak, and I think for them to participate in these proceedings, they're probably going to have to comply with reporting requirements that come from this court. So really the big one, of course, and it's the one all the news is reporting, is just about halting the military offensive.
Well, I mean, of course, that's always going to be the case with these kinds. I mean, we've covered enough court cases to know that you get little teeny pieces of cases are what it's always reported on and taken a look at. Maybe one last thought here before we move forward to what we thought we were going to be dealing with this morning internationally. And I think that's one of the items that maybe more on the left right now have struggled with, which is to say they oftentimes see international organizations as being these kinds of very key pieces to the order. And on that one, I actually agree, right? I'm a liberal on that front. And I think sometimes when you see them in operation and you watch them day to day, they feel a little bit less effective than you would like. And I know that's something that sometimes you've been frustrated with, but this is par for the course when it comes for the purpose of sovereign interactions, like with the ICJ. What are your thoughts? Is there going to be any kind of pragmatic shifts as a result of this order? I know it's early to say, and I've already kind of said I don't think Netanyahu's going to change his mind. But is there any shifting calculus we should think about before we move forward?
Well, yeah, I think it's going to have some practical impact, but more indirect, right? It's not going to stop Netanyahu from continuing military action in Rafah and in Gaza, no matter whether that's consistent with or in violation of this order. But I think what it is going to do is it's going to, certainly make it harder for Israel's friends around the globe to argue that Israel's not law breaking, or so there've been these dialogues and discourses, for instance, about should the Palestinian state already be recognized internationally, and in the past week we've seen some moves towards that. Ireland recognized it, Spain recognized it, and I think to the extent that Israel is delegitimized internationally by non-compliance with these orders, that's going to have the effect of legitimizing Palestine globally. It's also going to make it harder, for instance, in domestic politics in countries that are pro-Israel, including the United States, including Germany. It's going to make it harder. And I think just even before this order came down, President Biden already put the first limitations on certain kinds of military aid. There's still plenty of U.S. military aid to Israel, but he stopped sending certain weapons that could be used against Gaza, and is only really continuing the weapons that can be used to protect the north against Hezbollah and Lebanon and Iran. And we actually predicted that was going to happen, right, and it did happen. Yeah, and so I think that I think that the impact here is primarily not on the what the Israeli military is going to do, but on how the rest of the world is going to interact with Israel and Palestine. I think that will have real and practical implications.
Well, I think we should turn then into another international story, because while that is involving, I think we've kind of said what we can. Again, it's early. We're taking a look at this. We've read through it quickly. But the one that we had really been preparing for, which was a little bit more of a shock, and I was even going to tease about all the international stuff always happens when we're doing the show, yeah. And sure enough, all the was that happening actually over in the United Kingdom. I'll be honest, I wasn't expecting this. It was a huge surprise from British Prime Minister Sunak, who called for elections on July 4. Now, just recall, right? The United Kingdom doesn't celebrate Independence Day. I just want to point that out for American listeners. No, in all honesty, the reason this is such a big deal is because the Conservative Party is down in the polls by double digits. And the goal, as the Wall Street Journal puts it, might be to have one of the biggest turnarounds of all time. In other words, kind of have a snap election in the hopes of portraying strength and moving forward. Now, a little bit of background for those who don't always follow us. In Britain, elections have to occur at least every 5 years. As a matter of fact, recently they have tried to move to a more fixed elective cycle. That's something that I kind of follow in my own research. But they can still call for elections earlier. And in this case, government didn't have to call elections until January, but obviously July's a lot sooner. So Labor on paper has a really good chance. And part of that, of course, is because Labor has again shifted. They had tracked significantly further to the left in the UK, and they have been more moderate in the past few years. And, case in point, they're no longer running on trying to re-enter the EU, which is a big move for Labor. But be that as it may, clearly conservatives think that this show of strength is a chance to kind of throw the other side off balance, have an election, and potentially still walk away, continuing to hold the reins of government for a particularly long period of time. And so, Ken, what are your thoughts about this? Again, surprise snap British election.
Yeah, I was quite surprised by it. So as I think you exactly correctly said, it's an unusual and maybe very bold move for the conservatives to call for early elections at a moment in time when the conservatives are down 20 points in the polls. Like usually you wouldn't want to do that.
Yeah, generally you'd hold out. You'd say, well, I'm going to wait. Let's see what happens.
We're doing a little better in the polls. And so I've been trying to speculate really about why they would do that. I'm not, I certainly can't claim any knowledge, but one thing that I was picking up on in some of the reporting is that just like in America, the one of the main issues for the conservatives, the Tories in England, has been anti-immigration, and they wrote in on anti-Brexit as kind of or pro-Brexit as a form of anti-immigration.
Okay, I'm there now. I'm there.
Yeah, pro-Brexit, of course, yeah, as a form of anti-immigration that they wanted out of the EU because they didn't want so many EU residents coming into Britain, and they I think even had their constituents probably objected even more to immigration from outside the EU than from immigration in the EU. But by their own measures and metrics, their failure on that front has been stunning. So that immigration has gone up, dramatically, like more than quadruple what it used to be since the Tories took over. And so I think that their own constituents, to whom that's a very important issue, are kind of despondent about that. And the conservative Prime Minister Sunak, he had really made a central point of how he was going to deal with that he's going to ship asylum seekers off to Rwanda in airplanes and boats. And he did make some arrangements with the Rwandan government to accept them. But that never happened. And they're not in any position just in terms of practicalities and logistics, to make that happen anytime soon. And generally, because a lot of the asylum seekers come across the English Channel in boats, there's going to be a lot more of that in the summer when the weather gets better. And I think that maybe he just thought this is only going to get worse. That if his voters want to see some successes on keeping immigration out, the longer the summer drags on, the worse and worse and worse that's going to get for him. And so he maybe was going to call for early elections before it got even worse. I think one other thing possibly that's a good issue for the conservatives now is that as in America, there was a lot of bout with very bad inflation, and that's mostly come under control now there as here. So I think, maybe right now is a time when he can run and say we've tamed inflation and not risk like letting it drag out longer and seeing if it goes back up. But those are sort of some speculations I had. But I do think the Tories are in for a pounding. I don't really see how they're going to make up this 20-point gap by July 4th. I don't know what you think about that.
Yeah, I mean, yeah, we oftentimes, when we're talking about American elections, we say, well, you got to be careful about the polling data at any one point. But that's a very different political environment in the United Kingdom. Elections are very, very short, right? So from the moment of being called to happening, right? I mean, we're talking July 4th. It's just not that far away. Yeah, you're talking just a little bit over a month. So polling data becomes much more useful in that case, right? And so, yeah, I mean, like you take a look at the polls and you go, okay, we're talking about double-digit downs. We're way outside the margin of error. We're way outside. Okay, well, maybe not everybody's responding the way you might hope. That's one thing. Oftentimes, when you're talking about conservative parties, that they're being underrepresented in these kinds of polls, but I don't think they're getting underrepresented by any 10%, And right. So, yeah, it leads to a lot of questions. I had not thought about the inflationary question, but I had certainly, and I agree with you, thought about the immigration question, and that is one area I had been looking at it more in context for the United States for other things that I'm doing, but there is increasingly bipartisan support for the closing of borders in ways that would have been unthinkable, say, 10, 15 years ago. Here in the United States, I was a little bit surprised, even among Democratic voters, how strong of an issue that is. So I haven't looked at that in the UK as deeply, but that very well could be something to tap into. Now, I recognize what you're saying, which is to say, well, it's gone up under their auspices. But as we both know, that does not necessarily determine how people vote, right? Because that determination is which group or party do we think has the better position on it. And then if it's on one of my top of the mind issues, I then trigger that as a voting mechanism. As a matter of fact, in the political science literature, we call that priming. So the fact that there's a lot of immigration things, the way the kind of way you're talking about it there as being a hurt for for conservatives, I think it's actually more likely to be helpful if they're viewed as being the anti-immigration party, which I think they clearly are. But yeah, I mean, again, but is there 20 points in that? I mean, are they going to be able to get that far into potential labor and moderate voters to make that up? It just seems unlikely to me. But maybe there's some polling that I'm not looking at, or maybe there was something internal they took a look at to say that's the case. The only other thing I'd really say about it, Ken, is if somehow they win, if they come back from that deficit polling, I would be terrified if I was Joe Biden.
Yeah.
Yeah. I mean, there's my last thought there. Other thoughts you have?
Yeah. So on the polling, so the New York Times did publish a little bit of polling data about issues in England, and they say only 20% of Labour voters in Britain rank immigration as a pressing national concern, although 65% of Tories do.
So much lower than the United States. It's not comparable then, is it?
Well, 65% of Tories, I think it means it's a big deal for the Tories, but I think a lot of those voters are quite disappointed with Sunak because really, as I said, immigration has gone up extremely dramatically in England in ways that are very visible and with lots and lots of boats full of asylum seekers coming in all the time. And everybody understanding, I think, in England that immigration's gone up a whole lot since the Tories have said that their big thing is going to be to stop that. So I do think that, having that position, of course, as you pointed out, someone who's anti-immigration will prefer to vote for a candidate who's anti-immigration. But yet I think there's a lot of, sense that Sunak has not delivered on any of his anti-immigration promises. So I think that would hurt him. And I certainly agree with you that if Labor can't win under these conditions, that's trouble for Biden. I guess one other thing I'd say is that in the UK system, which is a multi-party parliamentary democracy where often coalition governments have to be formed, it seems like some of the major third parties are probably going to play less of a role in this election than usual. For instance, Nigel Farage, who has sometimes captured a lot of the anti-immigrant vote with his Reform Party, he's not going to run, and he's not going to run because he doesn't want to split the vote on the Tories. Similarly, the Scottish National Party in Scotland for a while, which is a Liberal party, was getting more votes in Scotland than the Labour Party was. But they essentially have been greatly weakened. They had some financial scandals. They had their first minister, Nicola Sturgeon, had to step down in connection with those scandals. And the Scottish National Party is a greatly diminished party, and I think people will expect the Labour Party to get a lot more seats in Scotland than they would have if they had a third party to their left. So I think it's going to shape up to look a little bit more like an American election where the two major parties are really, capturing much more significant amounts of the votes, and the third parties are playing a relatively diminished role compared to what they've played in recent years.
Yeah, my only little bit of a clarifier on that, Ken, when you talk that they do in fact have a parliamentary system, but listeners beware, they do not have what you generally think going along with parliamentary elections. That is, they don't have proportional representation. So they actually share our single member districts with first past the post winner rules. So we actually borrowed that from the United Kingdom here in the United States. So we share those kinds of electoral rules. And what that means is they do in fact tend toward two major parties. The United Kingdom is kind of an outlier on that front, as you note, with having had some parties primarily due to regionality, as you had pointed out, which is something that's very particularly pronounced and unique in the United Kingdom as a whole. But yeah, just a little bit of an add there, because I know that sometimes that gets a little bit confusing if you haven't been, if you haven't taken an electoral politics class recently.
Yeah, and by regionality, of course, you're right. What you're saying is that in Scotland, the Scottish National Party got a lot of votes. In Northern Ireland, the Ulster Unionist Party got a lot of votes, or the Democratic Ulster Party, or Democratic Unionist Party. I know they keep changing their name, but these regional regional parties. But although I do think Nigel Farage and his Reform Party were mainly strong in England, so that wasn't purely regionality.
Yeah, that is fair, and that's again where they're a little bit unique among other single member district countries. Again, that kind of electoral policy generally pushes you towards two major political parties. Something we've actually talked about on the show a lot. Well, we should probably return to American politics and policy, Ken. Because we've had elections in the United States just this past week. And Tuesday, of course, including in your home state of Kentucky, there were primaries. And as has been reported on pretty widely, and something we might want to talk about for just a minute, is that protest votes seem to continue to be more persistent than they have in past presidential cycles. On the Trump side, even though she's out, Nikki Haley received over 6% of the vote in Kentucky, and another 4% of the vote remained uncommitted for well over 10% of the Republican vote. This comes after she received 20% of the vote in primaries the week before in Maryland and Nebraska. Now, meanwhile, uncommitteds have also cut over in Democrats, Biden's numbers, with 19% voting uncommitted. And unknown Dean Phillips even outdueling Haley with 11% of the vote, or in other words, about 30% of the vote going against Biden. Uncommitted has already secured 28 Democratic delegates, and that is larger than in any other presidential election. So, Ken, let's just start there for a minute. You know, we had talked about that earlier in the primary cycle, and I know one of the things you said was, well, it's still early, these protests. I mean, are these individuals really not going to show up and vote for their respective candidates? But as these numbers continue to grow, again, I don't think anyone is suggesting, well, I don't think anybody who understands the system is suggesting that these are voters who are going to, come out and turn out for the other side. But are these kinds of uncommitted voters a sign of people who won't show up? And does this indicate a particularly low turnout election? I am beginning to see signs of maybe one of our lowest turnout presidential elections. In other words, I think we went from one of our highest, and I think we're kind of being set up for one of our lowest. And I think that has implications. Do you agree with that, or am I getting ahead of myself when I take a look at Tuesday's primaries?
I think you might be getting ahead of yourself. I think Kentucky is an unusual state. Certainly, Trump's going to win Kentucky, but and I think the numbers you just talked about, reinforce that. But one thing that I think is unique about Kentucky, and you used to live here, is that the whole South. The whole South over the past 50 years, switched from being Democratic to being Republican. But Kentucky was probably like about the last place where people got around to switching their registrations. So uniquely in Kentucky, you had Democrats actually still having a voter registration advantage, I believe, until just 4 years ago, when the Republicans finally got a voter registration advantage. But a large number of those Democrats were already voting Republicans. So when you look at the kind of numbers where Biden did disastrously in the Democratic primary in Kentucky, I think that's real. I think a lot of those people who are still registered Democrats in Kentucky are going to vote for Trump. So
I think there's switchover vote. Okay.
Well, what I'm saying is there's many registered Democrats in Kentucky who
aren't Democrat nationally, effectively.
Yeah. They only vote Republican in federal elections. They may still vote Democratic in local elections, right? So that I think a lot of Kentuckians, Governor Beshear is a Democrat, and I think there's a lot of Kentuckians who are sort of the mind frame that they've always been Democrats. The Kentucky Democratic Party still represents them, but the Democrats in Washington, they have nothing in common with, and they'll vote Republican in federal elections. And so I think that kind of concept of voters who vote Democratic in state and local elections, Republican in national elections, is I think Kentucky does have unique political conditions that way. And
so
I
that
think
kind of that larger picture, though, where we see a lot of uncommitted and Nikki Haley in other states coming up against Trump. What would you say against the argument? Say, well, I hear that in Kentucky, but of course, we see this kind of being a more broad set movement. but you're still suggesting that that's probably not indicative of a low turnout. So expand that argument.
Yeah. So I was actually talking about on the Biden side, right? Biden did really, really disastrously badly in the Democratic primary in Kentucky, but I don't think Biden has done disastrously badly in many Democratic primaries. In most of the Democratic primaries, Biden's getting more than 90% of the Democratic vote. Kentucky was quite unusual that way. Now, in the Republican primaries, as you were pointing out, there's a consistent vote. I don't know if it's always over 10%, but it's usually usually around 10%, sometimes more, of Republican voters who are still voting for Haley or voting for uncommitted. I think that some of those voters may not turn out at all for Trump. Some of those voters may vote for third-party candidates like Robert Kennedy. Some of them may still vote for Trump. But in an election where the numbers are going to be tight, I think Trump has more to worry about from that than Biden does, because I think Biden's really only impacted by that in primarily in states that are only going to go for Trump anyhow. I would sort of say Michigan is the Democratic version of Kentucky there, where I think Michigan is a state where Democrats not voting for Biden could become a real problem. I don't think that'll be true in any other state. I think by and large we're going to be looking at battlegrounds deciding the election, and I do think the turnout will be as high as ever in the battlegrounds because so much attention will be focused on them.
So you don't think that the fact that Biden has missed out on 38 delegates to uncommitted is a larger sign in the same way that to this point, Trump missing 97 delegates to Haley is?
Right, that's really what I'm saying, because I think that the Democratic in the battleground states, other than Michigan, and I am bracketing Michigan here, but I think in the battleground states that the Democrats who realize that it's Biden or Trump, they may cast a protest vote against Biden in primaries, but they're probably going to come around to voting for Biden when it really gets down to that binary choice of Biden or Trump. Whereas I think there's probably more Republicans, and I know you were one of them, who really don't want Trump in there and are just more likely to not vote for Trump. I think the Democrats ultimately, in New York and California, maybe a lot of them won't vote for Biden, but that's because they know Biden's going to win. But I think in Ohio, well, not Ohio anymore, but in Wisconsin or Pennsylvania, those Democrats, no matter what they think about the war in Gaza or about student debt or whatever, they're not going to want Trump in, and they're going to realize that their states are going to make the difference.
Okay. Well, let's move on to our next story, which is, one of the other ones that we are kind of consistently doing in our wheelhouse, and that is a Supreme Court case. On Thursday, the United States Supreme Court upheld a congressional redistricting plan along a 6-3 split. The majority rule argued that the challengers had failed to show that the state legislature was primarily motivated by race when it moved black voters out of the state's first congressional district. Instead, they were just making the seats safer for Republicans, which is not unconstitutional. So here's the key. Gerrymandering, which I know this is something we do in the show a bunch, gerrymandering is in fact legal. As the court has long put it, there's kind of a box of political activities which is outside the jurisdiction of the court. And Alito argued in the majority opinion that it wasn't because the voters were black they got moved. They got moved because they were Democrats. And if they're moved because they're Democrats, that's a political move, and that's therefore outside of the jurisdiction of the court. Keegan argued that was nonsense. Since the district court had found it was about race, what new evidence indicated it was not in her dissent? As Alito puts it, what if race and partisan preference overlap? And he says, okay, let's say they do, or they, in his words, collide. For Alito, it requires the challenger to prove it was the predominant motivating factor. Just because you racially gerrymander doesn't mean you're racially gerrymandering if there's partisan preferences at work. So, Ken, what do you think about Alito's decision?
I think both the corruption and the racism of that decision is just not unexpected, but just appalling. I mean, not only a deeply corrupt decision, it's a deeply racist decision. And even on the first issue that you talked about, political gerrymandering, although he said in this opinion, he sort of took it as a given that political gerrymandering is constitutional. The court has never held that, right? In fact, implicit in what they did hold, which is what you also said, which is that political gerrymandering cases may be non-justiciable. In other words, the court may not have jurisdiction to resolve them. That necessarily means that the court has abdicated its responsibility to say whether or not political gerrymandering is unconstitutional. That the logic of saying something is non-justiciable is to say we're not even going to weigh in on whether it's constitutional or not because we're not going to do anything about it, even if it's unconstitutional. So I think for him
that is a long-standing position of the court. Though I mean that's not like something that Alito has pulled out, today.
No, it is something he pulled out today. It's not a long-standing position. They only said that political gerrymandering is non-justiciable in the Rukow case, which was just a couple years ago.
But before that, they had explicitly rejected to even taking up cases on gerrymandering. So to me, it's true that the court didn't, until that point, write it down. But the history of the court just simply didn't take up gerrymandering cases.
Well, in Davis versus Bandemeyer, where they didn't take it up, the dicta in that case said that it probably is unconstitutional, but it's just that the court doesn't have a metric. There's no no judicial standards for figuring out how to draw a line between what's an unconstitutional gerrymander and what's a legitimate districting. So in other words, when they first introduced this idea that these cases might not be justiciable, the language in that opinion, that was Davis versus Bandemeyer, said it is unconstitutional, but there's nothing we can do about it. And somehow over a very slow process of transformation that was never explained, and not really until this week's case, Alito somehow reinterprets this idea. Political gerrymandering is unconstitutional, but the cases are not justiciable, to just saying political gerrymandering is perfectly constitutional, and there's never been any explanation for that shift, and it's
but
corrupt
even
here.
Even if you go further back, I mean, the court in Wesbury v. Sanders and the cases that surround that purposefully and carefully separated themselves from gerrymandering issues apart from mathematical issues, right? And so kind of famously in that case, the court says, well, look, one constitutional issue that is in fact at play is the fact that any particular person's vote in a particular district has to be equal mathematically to another person's vote in other people's district, because we had what we would call, for years, we had huge amounts of malapportionment, especially in places like, well, in that case, particularly in Memphis. Oh, no, that's not that way. It's the other cases in Memphis. Anyway, point being, though, is
you're thinking of Baker versus Carr.
Baker versus Carr, yes, the Memphis case. And so the court has long stayed out of the idea of partisan gerrymandering, again, heading that far back.
Well, in Baker versus Carr, when they struck down malapportionment and said that districting has to be done one person, one vote, that's a 1962 case. In Memphis, the one you're thinking of.
Yes,
they didn't stay out of that. They ruled it. They required redistricting because you had a violation of that one person, one vote rule. And the 15th Amendment, since the Civil War, has prohibited race discrimination in voting, and it's given Congress power to enforce that through legislation. And the Voting Rights Act of 1965 does contain quite a lot of standards for how to enforce that, some of which were very clearly violated by what South Carolina did here. But that doesn't even get discussed because these are provisions that in recent other corrupt precedents the court already struck down. So, for instance, the Voting Rights Act would require Justice Department to give pre-clearance before you could even redistrict in a way that diminishes African American voting power. And that's a provision that Congress legislated in order to protect against racial gerrymandering. And the Supreme Court in the Shelby County case about 10 years or 15 years ago said that that's not enforceable. So this court's kind of been picking away at all of the mechanisms that exist, norms against political gerrymandering, norms against racial gerrymandering, structural norms like preclearance that would be required to make sure there's not racial gerrymandering. And now in this case, they even went so far as to say that even where it was actually proved to a 3-judge panel of Republican judges that there was a plan actually devised and implemented to make sure that no more than 17% African Americans were in any of these voting precincts, and that was proved. The court says, well, that doesn't matter. That even though that was in fact racial gerrymandering, according to this court now is something that, not only can the court not do anything about, but in fact that is affirmatively legal, even though the 15th Amendment and the Voting Rights Act say that it's illegal, just because racial gerrymandering benefits Republicans. It's appalling.
So, I mean, I guess my question for this, though, is to suggest that this is one of those issues, I think, sometimes where I think you have blinders.
Yeah.
I think you start from the position that, Alito is corrupt and attempting to do something evil. And then you work backwards from that location to get to the position where you are. And in this case, for example, right, where you talk about, well, they're putting political gerrymandering to the side as part of your argument. But again, of course, there isn't a historic set of the court dealing with political gerrymandering. And while I also, agree that that there has been a judicial switch on the understanding of the Voting Rights Act, that is in fact what the court found. Because
it's a corrupt court. That's what a corrupt court.
Well, right, but your point is, okay, so any decision with which you've disagreed with the court, so 15 years ago you disagreed, it's corrupt, so following that is then corrupt. How is that any different than Republicans who argued that, say, Roe v. Wade was corrupt and therefore now we have to, overturn it? Courts make decisions on a variety of ideological bases and law. And you have an a priori that says this particular way of viewing it is corrupt, ergo everything that follows there from it is corrupt. How is that different than the conservative who says...
It is different. It is different because in the voting context in particular, the literal logic of this opinion, like literally it's what the opinion says, is that as long as this is being done for the purpose of helping Republicans, that makes it legal. You couldn't be more corrupt than that. That's the very definition of corruption. That no matter what the Constitution says, no matter what the Voting Rights Act says,
the Constitution doesn't say anything about political gerrymandering.
Yeah,
that's one of the potential problems with it. We can have that argument.
The Constitution says plenty about it. The 15th Amendment says that no one should be deprived of their right to vote based on their race. And then Section 2 of the 15th Amendment says Congress has the power to enforce that prohibition by appropriate legislation.
Absolutely true, but that first portion doesn't. So your ability to deny voting race. Sorry. Finish.
Congress has enforced it by the Voting Rights Act. So we have a definition in the Voting Rights Act of what it means to deprive people of their right to vote based on their race. And Congress has used the power that the 15th Amendment expressly grants it to say, if a legislature intentionally dilutes the impact of African American votes for the purpose of making sure that African Americans have less of a chance to elect people that they want to elect than white voters have through districting, then that's what it means to deprive people of African Americans of the vote based on their race. Congress has express authority under Section 2 of the 15th Amendment to enact that law. Congress did enact that law, and there was a trial here, and the trial was held, in fact, not even in front of a jury, but in front of 3 Republican judges. And the 3 Republican judges found facts that show that exactly what the Voting Rights Act says is illegal, is exactly what the South Carolina legislature did.
So in this case, I guess my question then is your argument here that partisan gerrymandering is in fact unconstitutional under the 15th Amendment.
Yes, it is. No, not under the 15th Amendment, under the First Amendment. But yeah, I mean, that's what the
Under the
Supreme
First
Court has
Amendment?
said. Yeah, that's what the Supreme Court said in Davis versus Vandemeyer, that partisan gerrymandering violates the First Amendment. The court held that, but then it also held that it has that it's non-justiciable because there's no judicially redressable standards for figuring out what's a correct kind of districting. So in the partisan gerrymandering context, when the court actually considered it rather than just mouthing lies like Alito did in this case about what the court had previously held, the court said that we can't redraw districts because we don't have any judicial standards for doing it.
Well, yeah, of course. How would the court draw partisan or nonpartisan or any particular?
Right, but the point is, it's easy to do it with racial. It's not that practical problem isn't there. So racial gerrymandering violates the. It's easy to say that they drew this district for the purpose of diluting the African American vote, right? So you just go back to the old district. It's easy to prove. I mean, not easy. It doesn't happen in a lot of cases, but it's provable, and it was proved in this case that the South Carolina legislature, in fact, drew these districts for the purpose of making sure that African Americans
a Republican win. Yeah, for sure.
No, African American votes could not have the same potency as white votes. That African Americans would have less power because of the redistricting. To each African American would have less power to elect someone they wanted than white people would have to elect someone they wanted. And Alito doesn't even refute that. He just says it's fine to disenfranchise African Americans because they wouldn't vote for Republicans. I mean, that's literally what he says.
Well, what he precisely says is that when you have two different factors that are happening at the same time, you have people of a particular race and you have people of a particular political preference, that if you're drawing boundaries for political purposes, which everyone does, that is in fact legal. I mean, and that is the takeaway of his argument there. And I think what you're suggesting is that is. I think what you're really suggesting is that ought to be considered judiciable, and it ought to be not considered to be considered by the court as opposed to have been ignored. And that's a position one can take, but it's just simply not one that the court has done.
It's not actually what I'm saying, though. Although I'm being agnostic about whether political gerrymandering cases should or shouldn't be justiciable, but what I'm saying is racial gerrymandering cases absolutely are justiciable, and it shouldn't be a defense to a meritorious claim that districting has unlawfully been racially gerrymandered to say. But the court doesn't have jurisdiction to consider whether it's been politically gerrymandered. I mean, whether or not the court has jurisdiction to consider that it's been politically gerrymandered, the court absolutely has jurisdiction to consider whether it's been racially gerrymandered. And in this case, it was proved that it was racially gerrymandered. In fact, it wasn't even contested by Alito that it was racially gerrymandered. He didn't say that it wasn't. He just said racial gerrymandering is permissible as long as it benefits Republicans.
Well, again, that's where, again, not exactly. No, what he is saying is when you have two particular different factors that overlap, the burden of proof is therefore then on one particular side of that, because you do have the ability. Now, again, that's where I come back to this, right? So he argues if you've got two factors, political preference lining up with racial preference, that in that particular instance, the burden of proof is on those who suggest that race is the cause.
Yeah, but he's wrong. But the point is the political gerrymandering argument that he's making. I mean, he's lying about what all previous precedents said, because they do say it's non-justiciable. There's no precedent that says that political gerrymandering is legal. And so you've got, they shouldn't be considering the role of political gerrymandering if it's non-justiciable. If it's non-justiciable, it shouldn't figure into this equation. So the only thing that should figure into this equation is whether there was racial gerrymandering, which is justiciable. And even he says it's justiciable. But he says, he makes up this idea that it's legal if it benefits Republicans. If he's going to stick to all all the precedents that say a political gerrymandering claim is non-justiciable, then he should not be considering in this case whether there was political gerrymandering.
But wouldn't that indicate that it is then a non-justiciable issue?
No, the racial gerrymandering is justiciable.
Right. What I'm saying is like, so if you take his argument, what you're suggesting is he's lying. And what I'm suggesting is that I think the argument here is if you say, okay, I believe it's falling primarily into the box of partisanness, it is.
He shouldn't be considering whether it's in that. It's not legitimate to consider whether it's falling in that box if that's a non-justiciable issue.
But of course you have to, because that's because you got to decide if you can decide. That is part of what a court does all the time.
No, you got two issues. One's justiciable and one's not justiciable. The racial gerrymandering issue is justiciable. The political gerrymandering issue, as you keep pointing out, has been held by the court to be non-justiciable. So they should decide the issue they have jurisdiction to decide. They shouldn't decide the issue they don't have jurisdiction to decide.
And okay. I hear you. Well,
also, I called him a racist, and I do want to back that up. There's intensely racist language in this opinion. He says, if we think about, a claim that, which has actually already factually been proved, that these legislators took account of race and intentionally and purposely diluted the African American vote. He says to even raise that claim is to accuse these legislators of offensive and demeaning conduct. We should not be quick to hurl such accusations at the political branches. We should be wary of voting rights plaintiffs who seek to transform federal courts into weapons of political warfare through racial gerrymandering claims. He's basically saying that even when racial discrimination actually happens, the evil is to call it out. The evil is not to do it. Right. I mean, that I don't think you can look at that any way other than
say your take on that again. I don't know if I'm not even sure I followed what you said. So say that one more time.
OK, so you have a legislature here that did, in fact, racially gerrymander. They did, in fact, try on purpose and succeed at making sure that African American votes couldn't count as much as white votes. That was proved in a trial. And even after that was proved in a trial, even after the plaintiffs here not only raised these allegations, they proved these allegations. One of the main arguments that Alito makes is that that because the state legislators have taken an oath to uphold the Constitution, that it therefore is you're accusing these legislators of offensive and demeaning conduct, and he says by accusing them truthfully of having engaged in racial gerrymandering, that you're accusing them of offensive and demeaning conduct.
Well, I'm reading that portion that you're having here, but I mean he's not arguing that this part is truthful. So, I mean, you can disagree with him.
But it is truthful. It's been found, the claims have been found to be truthful by the lower court, and he doesn't actually say that the lower court got that wrong. He just says it's okay to dilute the African American votes because the African Americans would vote for Democrats.
He in fact says that it does not rise to the level of strict scrutiny. So that's what Kagan disagrees with him on. She says, well, look, there wasn't a reason to overturn on that front. So, I mean, again, you can disagree, but he is certainly not suggesting that the lower court was correct on that finding. He argues very explicitly that when you, in his words, that the plaintiff is not able to determine that race drove the mapping of the district lines under the standard of strict scrutiny, where the state's use of race is narrowly tailored. So, I mean, again,
he doesn't. You're misreading that. That he's saying there that because, in his view, they wanted to benefit Republicans, that even if the means by which they did that was by disenfranchising African Americans based on race, he says they're allowed to do that because they're allowed to benefit Republicans. So he can't possibly. He doesn't even have authority to reverse the findings of fact that the lower courts made. The Supreme Court's not a fact-finding court. And the findings of fact, which the lower courts made, are that this was that they took account of race, and that in fact, there's specific findings of fact on that they didn't allow any of the precincts in that district that's now Nancy Mace's district to have more than 17% African American voters. That
but again,
cap was put on there intentionally.
On page 17, he says, in this case, the district court clearly erred because the challengers did not meet this quote unquote demanding standard. O'Connor concurring. They provided no direct evidence of a racial gerrymander, and their circumstantial evidence is very weak. Instead, the challengers relied on deeply flawed expert reports. So, no, I mean, again, we can disagree with him, but he's clearly not saying precisely what you're saying there.
Well, I think he is. I think he is saying that they were supposed to somehow disentangle the racial gerrymander from a political gerrymander, and that's what they failed to prove. So I think he's saying that that everything that the legislature did could be explained on the grounds of that they were trying to benefit Republicans, and that that somehow the burden on the plaintiffs should have been to show that they cared about race even more than they cared about partisanship, and that's what they failed to prove.
Well, they also failed to prove, they've also, in his view, used the wrong analysis when determining if race was the primary factor. And he sets that into a 4-part in his goal. And he even says that in the first part, we set out to review the appropriate legal standard for the court's factual findings in its racial gerrymandering cases. And what he says there, ultimately, is that the district court's factual findings are clearly flawed under the correct legal standard. So, again, he is not suggesting precise. I mean, again, I'm not suggesting we have to agree with Alito.
Yeah. No,
but I am disagreeing with your reading of him deeply because you are reading into his. I mean, I think you're reading more there in part because you already are kind of. I mean, you're frustrated with him to start with, right? He's it kind of goes into like, listen, the core is this corrupt thing, and therefore it's going to be a corrupt decision. And again, we can disagree, but that I am disagreeing with you on this pretty deep.
Okay. Well, I think you're not. I think you're not putting enough weight on his final couple words that you read. Those words under the correct legal standard, right? That I think he's not saying that the facts they found aren't the facts that he's using. He's saying that they didn't apply what in his view would be the correct legal standard, which would be some heightened burden to disaggregate.
But he also says, end quote, the factual findings are clearly flawed.
Yeah. Okay. Well, I think we've hit the wall on this, but I want to. I don't want to keep repeating myself here, but I do want to point out that that language that I did sort of highlight about that we can't accuse a state legislature of offensive and demeaning conduct that bears a resemblance to political apartheid. We can't be quick to hurl such accusations at the political branches. We have to be wary of voting rights plaintiffs who seek to transform federal courts into weapons of political warfare through racial gerrymandering claims. He basically is saying he's really offended that people would raise these claims, and that's what offends him. It's not offensive that legislatures would actually racially gerrymander or dilute African American votes. It's offensive that people might accuse them of that. It's very kind of almost like pre-Civil War Confederate type language.
Well, I mean. Is it really wrong to suggest? I mean, I think you're inferring there that by saying that this is a high insult, that therefore it ought not to happen. I think he's just simply suggesting, hey, we need to be thoughtful about when we are throwing that kind of language around. I mean, I don't see why that's
it's not being thrown around. It's being litigated. The accusations need to be proved in court, and they were proved in court. And it doesn't happen every day.
And again, I understand at the district court level that is what they found. But now the Supreme Court is suggesting that finding was in fact an error, correct?
No, I don't think they found that the finding was an error. I think they found that the finding was.
Look at A and B of Alito's opinion is in fact that those findings are in fact an error. That's where I think we are disagreeing most deeply here. I mean, again, it is clear. I mean, when you get to A and B of his opinion, he is suggesting that, as he says, that South Carolina, the district court found that this target maintenance is in fact inaccurate, and that the primary evidence that they used for that finding is inaccurate. Because again, that is what that is what the dissenting measure even took aim at, right? So they're saying, Alito, you're absolutely wrong about that.
Also, Justice Thomas, by the way, Justice Thomas also took aim at that because it's so inappropriate for a judicial role. I mean, if what he's doing is saying the lower court got all the facts wrong, and I don't really read him to be saying that, but I think Thomas also, like you, did read him to be saying that. Then even Thomas said in his separate opinion, that's completely not appropriate for Supreme Court judicial decision making to just say that the lower court got all its facts wrong, because the lower court is where the facts are found.
Again, I'm not. That's not where I'm at. Yeah. So, but I think again, what I hear is, so when we're kind of taking this on, I think again, you're reading the Alito opinion in a way that neither his dissentor nor his concurrers are reading it.
Okay, I mean, I'm just saying whichever way. I'll grant you that, right?
Okay.
But whether what he did here was just completely because of his own ideology and his own politics and his own racism, say, well, if the only way I can overrule this lower court is just by completely outstepping my role as an appellate judge.
Why does he have to be a racist? Why can't he just be an ideologue in this particular instance? Like, what
I think
about
it? I think he's using racist language in the opinion, that the language that I pointed out. That's why I'm calling him a racist, because I think to say that it's it's offensive and demeaning to hurl accusations at political branches that they've done something racist, and that we are not going to be very open to voting rights plaintiffs who want to transform federal courts into weapons of political warfare. He's basically saying that African Americans who just want to have equal voting rights, should not have that and should not have any mechanism for getting there. And I think it's, frankly, of a piece with, and I think we were going to talk about, these Stop the Steal flags that he was flying at both of his houses, where, his basic idea that Trump won the 2020 election. I don't think you can separate that from the idea that minority votes shouldn't have counted. Right. I mean, all of the Stop the Steal stuff, ultimately, to the extent that people believe that Trump won that election, what they basically believe is that the fraud is that minority votes got counted.
Yeah, I mean, that was something else that we really did want to take on. Was we wanted to talk a little bit today about the Alito and the flags. Man, we've gotten long. But why don't we finish the show just like on that footnote here a little bit, which is effectively that the New York Times reported that about 7 days after the January 6th, that there was an upside down American flag at the primary Alito residence. And then later in that summer, that there had been a flag, which is now in some quarters is originally a colonial flag, but in some quarters is now tied to Christian nationalism, flown at his not his primary residence, but his kind of vacation home, if you will. His only really commentary on this has been that at least the upside down flag had to do with a conflict between a wife and his wife's and the neighbor, and so there's a little bit of that context real quick, and because you want to bring that in here, so please.
Yeah. Well, I mean, of course he's lying about that, right? Because if there may have been a conflict with a neighbor, but if this only had to do with the conflict with a neighbor, you wouldn't see a similar flag flying at his other place on the Jersey Shore where there wasn't a conflict with a neighbor. I'm sure he's also lying about his wife being solely responsible for this. It's kind of inconceivable that the spouse of a Supreme Court justice, wouldn't realize that could implicate or impute the Supreme Court justice if that was flying at their house. And they must have had some kind of discussion about that. I mean, I don't know about you, Trey, but I don't think I'd fly a flag like that at my house without checking with my wife if that was okay with her. And I'm not even a Supreme Court justice, And
I'm the wrong person. In Florida, I was very much the outcast. I was the only person who did not fly an American flag in my for my house. I didn't put anything out. I never did do that. And so my neighbor across the street actually took grave issue with me for not flying an American flag and therefore demonstrating that I was, well, I won't use his exact words, but one of those intellectuals who hated the country because I would have had a much bigger pole. That is not a tease. Those were his words than I did.
But did you discuss it with your wife?
No, we had never talked about it. We never talked about putting up a pole, not putting up a pole, how we fly a flag, not flying a flag.
Neither of you were interested in putting it up. If there'd been a disagreement between you and your wife, would you have talked about that?
Oh, of course. I mean, again, if you're having a disagreement, I mean, I'm sure one might.
That's essentially what Alito's saying, right? He's like, well, I disagreed with my wife about this, but we never talked about it, so she just put it up, even though I'm a Supreme Court justice. It seems so unbelievable, and doubly so when it happened at both houses.
I mean, again, my guess is he probably had to have known about it to some extent. Although I say that, and having worked with a lot of individuals and their residences, plural, the extent to which owners at a certain strata know in detail what is happening in those as residents might be shockingly lower than one might hope. But be that as it may, I'm not sure it really demonstrates much of anything one way or the other. But I hear that point. But I do think we probably need to. Yes.
Can I just say, I mean, I agree that in a big sense, it doesn't demonstrate anything new. It only confirms, what I've been saying for a long time, which is that he's a corrupt judge. He's going to decide every case based on, how it benefits the Republicans or how he would like it to come out without regard to what the law actually says.
So because he takes ideological positions, he has to be corrupt. And ideological positions about which you disagree, of course, and therefore
he does it here in violation of
corrupt.
Law, right? So there's a lot of law that he was violating, and so I don't want to make it sound like I don't want to make it out like his decision to put a flag up may have been bad judgment, but didn't violate the law. It definitely did violate the law, right? So there's the flag code itself, which is in Title 4, Section 8 of the U.S. Code, 4 U.S. Code Section 8, says no disrespect should be shown to the flag of the United States of America. The flag should never be displayed with the Union down, except as a signal of dire distress in instances of extreme danger to life or property. So that's a statute that's in the U.S. Code. There's also various canons, including ones that do apply to the Supreme Court, that he violated, because the Supreme Court did recently finally adopt an ethics code, after they didn't have one before. And the ethics code does include statements that say that a justice should respect and comply with the law and act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. A justice should disqualify himself or herself in a proceeding in which the justice's impartiality might reasonably be questioned. That is, where an unbiased and reasonable person who's aware of all the relevant circumstances would doubt that the judge could fairly discharge his duties. And the judge should not publicly endorse or oppose a candidate for public office or engage in other political activity. So all of that's in the new canons that Alito himself was part of the unanimous vote to adopt. And the upside down flag thing has actually been in the U.S. Code since the dust-ups about flag burning in the 90s. That's when the U.S. Code was amended, I think 1998, to add that section that.
Yeah, I'm glad you brought that up. I was going to tease a little bit that that a leftist would be pointing out a very conservative portion of the code in response to a Supreme Court liberalization of that in Texas v. Johnson.
Yeah, right. And also, I will say, I actually am open to the argument that code language I just read violates the First Amendment. But I still think that that shouldn't be, if I wanted to fly an upside down flag on my house, which I don't, I'd be willing to argue that I have a First Amendment right to do it, even though it violates the Title IV. Yeah. But I think that a Supreme Court justice who's under all these other ethical canons not to engage in political activity should be cognizant of the fact that the Congress has determined that this is kind of an improper form of political speech, and whether or not there's a First Amendment right to do it, he shouldn't be engaging in political activity and political speech like that at all.
Well, I'll say this is going to be one of those ones where, I wish that we could do a 2-hour show, but this is probably where I want to keep going. But I think everybody else is saying it's time. It's time. So I am going to pause us there and kind of let you end us on that note, because we're hitting well over the hour mark. And so if you're still with us, I really appreciate that because I get excited about this kind of stuff. And I hope that if you've been listening for an hour and 10 to me and Ken, arguing about Supreme Court cases and an ICJ case and commas, you must really love American politics and policy. And so, again, if you've made it all this way, it might be time. This might be your sign. This is your sign that it's time to become a member and a supporter of the Politics Guys, right? And I mean that we're laughing about it, but I mean that honestly, right? If you're here now, you should be a supporter of the Politics Guys. And if you want to do that, head to patreon.com/politicsguys. There's all different kinds of levels of support. And this is the kind of stuff I love to kind of then talk about more. I can tell you, Ken, right now, you're not going to, you won't be there to defend me, but this is going to be a Discord topic. I can hear it now in 3, 2, 1. Yeah, Trey, how dare you? But we would love you to be a part of that. And that is one of our levels of support in patreon.com/politicsguys. So if you head there, you can take a look what it means to be part of our active Discord group. And again, I mean, it's a lot of fun. It's to do that, whether I'm on the winning or the losing side. I don't know even what that means, but, I guess the more or less popular side. There's other ways you can support the show, of course. There's Venmo, where we're at Politics. There's also PayPal. You can see all of this and more in our links in the show notes. If you'd like to don't forget one of the big things you get, and I was talking about at the beginning of the show, is we do have the supporters exclusive midweek show. Now, if you'd like to get that midweek show, but you're just not in a position to do it, don't forget you can always reach out at mail@politicsguys.com. We can get you set up. Ken and I are going to be continuing our conversation through the U.S. Constitution. Now, whether you're a supporter or not, we really would appreciate it if you would rate, subscribe, and otherwise just kind of blast the podcast. We would really like to get out there a little bit more. And so it means a big deal. Include us in your posts, tag us, tag me specifically if you're interested in having conversations in other places at Trey Orndorff on X and otherwise. If you want to see all of our links to things, both Facebooks and X, you'll find those in the show notes. You can also email us old school at mail@politicsguys.com. As always, I want to just have a huge shout out to our executive producers of the Politics Guys, who are Bruce Johnson, Wilma Marino, Daniel Toe, Ryan Beasley, and Don Oglesby. Thank you all, and we'll be back with a new episode next week, and I hope you'll join us then.
This podcast is part of the Democracy Group.